Legal protection in the workplace for sexual affinity. In my presentation, I will be discussing the legal protection that is in place for the LGBT community. In my research, I discovered the different types of sex discrimination, which includes sex stereotyping, gender identity, and sexual preference, all of which are protected by the U.S. Constitution. Sexual affinity can be described as the right to love whomever one chooses to, without regards to sex, race, or any other label applicable to human beings. With the legalization of same-sex marriage in all 50 states, it would appear that much progress has been made garnering equal rights for the LGBT community. However, in both the private and public workspaces, these members of the community still face discrimination. It seems that their employers may not understand the rights that their employees are entitled to under the United States Constitution. Although gender is not mentioned, the Civil Rights Act of 1866, the Equal Protection Clause of the Fourth Amendment, and the Civil Rights Act of 1964 all serve as the foundation for adjudicating sex discrimination claims as they relate to gender inequality and sex stereotyping. The LGBT community has faced discrimination mainly because of their inability to conform to societal norms of what gender is, also referred to as sex stereotyping. When the Civil Rights Act of 1964 came along, sex discrimination referred to situations where a male was selected over a female for a position when equally qualified, or in instances where female workers received less pay for doing the same work as their male counterparts. It was made effective 20 years before the American Psychological Association first identified gender identity disorder in 1980. To keep things straight from a legal perspective, there is sex and then there is gender. Sex is a person's scientific classification. It's his or her biological genetic makeup. Gender, on the other hand, pertains to the characteristics that a society or culture appoints as masculine or feminine. Hidden at the core of sex stereotyping is the idea of normal behavior. That is, the idea that people should behave in a certain way because they belong to identifiable groups. The United States Equal Employment Opportunity Commission, or EEOC, is responsible for the administration of civil rights law in the U.S. In 2006, there were almost 24,000 discrimination claims and 20,000 retaliation claims filed under the Civil Rights Law of 1964, Title VII. The EEOC finds that discrimination against a person based on their sexual orientation or gender identity is unconstitutional. Case in point, Smith versus the City of Salem. This case is often used as a testimonial for other sex discrimination cases. Smith was a firefighter for the City of Salem, at which time she began a physical transition to become a female. She was also diagnosed with gender identity disorder. During this time, her fellow firemen and supervisor made many disparaging comments. The City of Salem required her to undergo 3 separate psych evaluations in an attempt to coerce her into resignation. Finally, Smith was suspended for a minor infraction, and she felt that it was due to her transsexual status. She filed a sex discrimination claim under the Civil Rights Act of 1964, Act 7, against the fire department and the City of Salem. The case was dismissed in trial court because the judge ruled that transsexuals were simply not protected by Title VII. The court's reasoning suggested that men who are mistreated because they wear dresses are harassed because they are transsexuals, not because they are men. In essence, the judge determined that Smith's gender identity disorder was the true cause of his discrimination, which could not qualify for sex discrimination. The trial court's ruling was ultimately reversed by the U.S. Court of Appeals. It is not fatal to a sex discrimination claim where the victim has suffered discrimination because of his or her gender nonconformity. Gender nonconformity is not a defense for discrimination and does not exclude parties from being able to protect themselves using the Civil Rights Act Title VII as their reasoning. Another case example. David Baldwin versus the Department of Transportation. David was a temporary worker with the Department of Transportation. He was an openly gay man in a relationship with another male. His supervisor often complained about him being a distraction and not wanting to hear about gay stuff whenever David made mention of his partner. After 18 months, a permanent position became available, and according to policy, he would be given preferential consideration. When he was not selected, he believed it was due to his gay status. Baldwin filed a claim within the DOT for sex discrimination under Title VII. The DOT denied his claim, citing that it should have been filed within 45 days of him knowing that his temporary position was ending. They also claimed they did not have jurisdiction to implement Title VII for sex discrimination in a sexual orientation case. The EEOC ultimately decided to reverse and remand the DOJ's decision. According to the EEOC, the standard applied to determine timelines begins when complainants reasonably should have first suspected discrimination. The EEOC presumed that David Baldwin did not truly feel discrimination until he was not granted a full-time position. More interestingly, though, was the EEOC's response to the second part of the DOJ's response. The Department of Justice, as an agency, is expected to act on behalf of the Constitution in matters of the legal complaint process. The EEOC provided its stance as a guideline for resolution as it pertains to handle discrimination issues. They advised that agencies should treat claims of sexual orientation discrimination as complaints under Title VII and process such complaints through the ordinary channel. Equity for LGBT citizens is currently a hot-button issue. The number of related sex discrimination cases filed have only decreased less than 5%, while retaliation claims are up almost 30%. As society tends to evolve over time, equity for all people means accumulating more categories of people to the spectrum of who is protected. Many of the laws were written well before groups such as homosexuals, transsexuals, bisexual, and more were identified. However, the U.S. Constitution serves to protect all of its constituents.